Well, you'll see. Close the door, please.
All right, we'll take up file 2023-58926. Austin Sicard and Tessie Powers both are present with counsel. Ms. Smolders is here on behalf of the plaintiff, Mr. Greer on behalf of the defendant. This is the date and time set for hearing on a couple of things. Mr. Sicard had filed a motion regarding custody, which was adjourned because he hadn't properly served the other party, and she wanted to hire a lawyer, which she has now done, and this matter was set for hearing today. The defendant also filed a motion to establish paternity and essentially request indicating that Mr. Sicard was not the biological father of the child, although the parties have, it appears, executed an affidavit of parentage, although that was not attached to your complaint, sir, and it says in the complaint that it is.
Sorry about that.
I don't have a copy of it attached to your complaint. However, I don't think it's in dispute that an affidavit of parentage was executed by the parties regarding the child, Damien. But now Ms. Powers has filed a motion to, I guess, revoke that. I think some things are agreed to moving forward. One is that the matter would be adjourned for evidentiary hearing on June 8th at 8:30 regarding both motions. To get to that part and to order a DNA test, though, Mr. Greer, I'll swear your client in. Ma'am, do you swear or affirm any testimony you give in this cause would be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you need to speak right up. And your attorney drafted a verified motion to establish paternity and filed that with the court on May 15th of this year. Are you familiar with that document?
Yes, I am.
All right, and you signed that document on May 9th, correct?
Yep.
Pardon me?
Yes, I did.
Okay. And in order for that motion to proceed to a DNA test and an evidentiary hearing based on the results of that DNA test, there are certain additional things that were not in the affidavit that have to be explored. And I would note that I sent the Revocation of Paternity Act quick reference materials to both lawyers so that they had those. So we don't deal with these a ton. Mr. Greer, your client's under oath here. Why don't you ask her some questions to establish the requirements that the court has to find before it can be moved on to a DNA test.
Thank you. Tessie, you filed a motion for a DNA test, right?
Yes.
To set aside the affidavit that he and you signed, correct?
Correct.
And now you're asking for it to be set aside, correct?
Yes.
Why is that?
Because I mistake of fact
Okay, what would the mistake be?
that I thought he was the father, and I went back and it doesn't add up.
So you did the math, went
Yes.
back 9 months
Yes, I did.
to a conception time,
Yes.
and you think he was where was he then?
Jail.
So he was in jail at the time, you think?
Yes, he was.
All right, and so now you're asking because of that to set it aside.
Yes.
All right, makes sense. That's all I have, Your Honor. I think you only need one of them.
Ms. Mulder, do you have any questions regarding that?
Yeah, I have a couple questions. So what was the date that your child was born?
On the 8th of
And
what? April.
okay. And do you know what your due date was when you initially discovered you were pregnant?
No, not exactly. I didn't. They helped
Okay.
me. Doctors are the ones that helped me figure out my conception.
Okay. And do you know if your child was born early or late or on the due date then?
He was born on time.
Okay. But how do you know that if you don't know what the due date was?
Because the doctors are the ones who told me what day I had to have conceived him.
All right. And when did you seek this advice from the doctors?
Yes, because I didn't know who the father was at the time, and he knows that too.
No, I'm saying, I asked, sorry, when did you seek this advice from the doctors?
When I found out I was pregnant and I went and got established with a OB.
Okay, so you found this out when you found out you were pregnant. So why did you sign the affidavit of parentage indicating that the plaintiff was the father?
Because at the time I thought he could have been.
Okay, no further
It was
questions.
close.
Yes.
Your Honor, I don't have anything else. I don't know.
All right. I'm just looking this over. So, well, all right. I guess, based on mistake of fact, I'll move this on for a DNA test. Parties
Thank
would
you.
both appear along with the child on Tuesday, May 30th. At what time?
My understanding is on Tuesday,
Oh.
May 30th, they just have to all, submit to the DNA test that day. I don't think that they all have to be there at the same time.
I think
My
they
client's
do.
work
Let's
schedule.
say-
I think they do have to be there, Val. I don't mean to interrupt you.
Oh,
Well, if there's a domestic violence, there's probably a no contact order. So,
Okay,
sir, what time can you be there on Tuesday, May 30th?
I can be there at 4 o'clock.
4 p.m. All right.
is it open at 4?
I think she's open till 5 or 6.
Okay, good.
Ma'am, can you be there at, say, 3 o'clock so that you and the child are both tested and then you're out of there before he gets there?
Yes, I can.
All right.
Okay, so she's got to be there by 3, and then Mr. Sicard has to be there by 4.
All right. And,
Okay.
and mom, this will be done at mom's expense. We'll reconvene on Tuesday, June 8th at 8:30 to consider the results of that, DNA testing and,
You
for
mean
either side.
Thursday, right?
Thursday, I'm sorry.
Yeah, okay.
For either side to provide testimony that would be necessary for the court to consider taking action as a result of the DNA test. Obviously, if it's determined that Mr. Sicard is the biological father, there probably isn't any basis upon which to further consider that motion. If it is determined that he's not the father, the court does not automatically enter an order vacating affidavits of parentage. There have to be findings made by the court based on evidence presented regarding the Revocation of Paternity Act child's best interest factors. They're a little bit different than the Custody Act best interest factors. The court doesn't automatically enter those orders absent testimony being presented regarding those factors. So that'll be on June 8th at 8:30. Mr. Sicard's custody motion would likewise be adjourned to that same date and time for evidentiary hearing on that. In the meantime, Mr. Sicard would have parenting time this Saturday from 10 to 6 and Sunday from 10 to 6 and Tuesday and Thursdays from 6 p.m. till 8 p.m. That would be supervised by his parents or Jeff and Crystal Wallace. When I say supervised, I call this a soft supervision. There don't need to be constant eyes on, but the supervisors have to be present in the vicinity of Mr. Sicard and the child to ensure the child's safety. They can go places together with a supervisor to parks, playgrounds, things like that. I know the child's pretty young, but that would be the parenting time going forward that Mr. Sicard would have pending hearing on the June 8th, as I indicated. There's been a drug testing order being entered concurrent here too to the other order. It's a reciprocal drug testing order. Either party can pay for a test for the other party, and the other party would have to appear for a drug test. Normally, that would be within 48 hours. However, if a test is paid for today, then the other party would have to appear before 5 p.m. today to supply a sample.
Don't we have 48 hours?
Normally you will, but for today's purposes, if a test is paid for today,
Why is that any different?
the 48 hours is designed to not unduly inconvenience a party with notice out of left field that they have to appear for a drug test, anticipating that not everybody may be able to drop everything and be there. Your client's already just 15 minutes away. If Mr. Sicard wants to pay for a drug test today and have her tested, she can be here from your office in 15 minutes. So I'm not finding that there would be an undue hardship for her to be here yet this afternoon. Mr. Sicard, is it your intent to pay for a drug test today?
Yes, sir.
What type?
Hair follicle.
When are you going to do that?
As soon as we get done here.
All right. So, Mr. Greer, you might as well just send your client up here. If it turns out that drug test has not been paid for by the time she gets here, I would consider reimbursing her for her time and the inconvenience of having driven up here from Fremont, but he indicates he's going to pay for that test. And that would be done today. Likewise, if your client wants Mr. Sicard tested today, I would have him appear and provide a sample today as well.
Thank you, Your Honor. We'll leave that option open. What about parenting time tomorrow? Where are we meeting? What are we doing here? We can't, obviously, Mr. Sicard can't pick the child up because he can't be around her.
Can I just interject, Your Honor? I know this is unconventional, so I apologize ahead of time. Is Miss Corndike in the waiting room?
Oh, she is, yep.
Is there any way that, I know we've kind of agreed to all of these terms. This is kind of miscellaneous at this point. The parenting time exchanges and whatnot. I have a 12:10 that I have to be at. Is it possible to let her in and then she can take over with coordinating those exchange locations?
Yeah,
So why don't you just order? I mean, we don't know who's doing the supervision yet, so.
it's either.
Yeah, we
gonna
do. We just stated all of those 4 people.
Well, there's 4 people, Val. Which one's doing it?
We don't, like I indicated,
We don't know, right?
we haven't been able to talk to those people because I asked
Right.
my client just this morning to give me names. So out of those 4 people, I don't think he needs to pinpoint which one is going to do what day, but out of those 4 people, he can pick and choose based on availability.
Judge, can we have a day? I mean, I don't know why my client's having to do the transporting anyway. She's not the one that got beat up.
The supervisor will coordinate the pickup and drop off with the defendant, with your client, Mr. Greer.
Do they have they got your phone number?
They should, yes.
Okay.
Does Austin have it?
Yes,
And
yes.
one last thing
Hey, Austin,
before
you got her phone number. You can give it to the supervisors to call her, okay?
Yes, sir.
Okay, thank you.
One last thing,
Good.
Your Honor, and I'll let Stephanie take over on this. My client has indicated he has a conflict on June 8th. So if Stephanie, you want to go through the schedule rather than having to adjourn after we get off, I'd rather, handle that issue right now if possible.
Oh. June
He says
8th.
he's not available till 4 o'clock that day, which I know I am available at that time if it can be changed.
To 4 o'clock?
That won't be enough time though. If we're taking testimony on those best interest factors and his custody motion and all that, I had the whole morning I was gone.
Got it. All right, I'm
Um,
going to log off and Stephanie, you take care of that, okay? Just that
Okay.
scheduling conflict.
Yep.
All right,
Thanks,
thank you.
Val.
Yep, thank you.
Call
Sorry,
me
you guys.
about Dieters, please.
I'll tell her that, John.
Thanks, Val, or Stephanie, I appreciate it.
Yeah, no problem.
I got the morning of the 15th, the next week, if that works better.
Okay, hold on. Let me look. Are we talking about June, Your Honor?
Yes.
Work for you.
I work at night, so
Okay.
that's for me.
All right.
Yes, that's available, Your Honor.
All right, June 15th, 8:30 then, should be good. I think that takes care of everything. Was there anything else?
I think that takes care of everything.
All right, good. I'll do that order and have it faxed over to Accurate Screen, so she'll be prepared if people start showing up.
Very good.
All right.
Thank you.
All right, yeah, thanks. We're all set.